The United States Navy Marine Corps Court of Criminal Appeals is now open and in session. God save the United States and this honorable court.
Seats, everyone. Thank you. Today is the date and time set for oral argument in the matter of United States versus Suchi. Are all parties ready?
Yes, sir. Yes, sir.
Mr. Burgdorf? You may argue.
Thank you. May it please the court. My name is Captain Jeff Liebenguth, and I represent the appellant, Corporal Todd Suchi. With the court's permission, I'd like to reserve 5 minutes of my time for rebuttal.
Of course.
Because the appellant pretended to be government employees, he should have been charged under 18 U.S.C. Section 912 with impersonating government employees. Instead, he was charged under Article 134, paragraph 86 of the manual, which only covers government officials, not employees. We know that employees are not covered in paragraph 86 for 3 reasons. First, the term's nowhere to be found in paragraph 86. Second, paragraph 86 is a military-specific offense. The harm it seeks to prevent is the exercise of pretended superior authority. It makes it an offense to impersonate E4s and above, but not E1s through E3s. So what we find is not only is the term employee not in paragraph 86, but its very construction amidst the class of military personnel that are analogous with employees, E1s through E3s, and yet covers the class of military personnel analogous with officials, E4s and above. And third, the common legal meaning of official and employee are different. In fact, the plain meaning of official is so plain that it's not even defined by the drafters within paragraph 86. And even if this court were to find that there was ambiguity in paragraph 86, that it could cover employees, when a criminal statute has ambiguity, that ambiguity should be resolved in favor of the accused unless there's some clear purpose justifying a less than literal interpretation. Otherwise, the narrowest interpretation is applied. In this case, not only is there no clear purpose that employees be covered within paragraph 86, but all of the evidence indicates that the drafters specifically and purposely omitted employees.
Counsel, I'd like to start with the duress issue.
Yes, sir.
Moving away from where you are. Because if, in fact, your client is acting under a state of duress, it doesn't matter under which theory the government is advancing. The military judge would have to inquire into the duress aspect in order to sustain a sense of voluntariness on the part of the accused by way of the course of his actions. Articulate for me, if you could, where you believe Judge McKenzie below was deficient in discerning whether or not duress was an applicable defense.
Well, for sure, he didn't make that determination on the record. And this court shouldn't indulge the government and try and answer this red herring question as to whether or not the duress defense was plausible or credible in this case. The question under United States versus Lee that this court need to answer is, was the potential duress defense raised? And if it was, under Lee and Cass Holding in United States versus Smith, the military judge was required to explain the duress defense to the appellant and then to elicit, to negate the defense. He should have asked him, do you admit and believe that you did not have a reasonable apprehension that your unborn child would...
Factually, where is the record deficient, though, by way of this court being able to discern that, notwithstanding the trial judge's omission of an inquiry, that from the record itself, this court could discern the facts necessary to determine that such a defense would not be applicable?
Would not be applicable, Your Honor?
In other words, is where in the record is there sufficient evidence to illustrate that the defense is not applicable, i.e. along the lines of the government's answer?
We can point to no such place in the record, Your Honor, and based on the briefs supplied by the government, we don't think they do either. they seem to rely on the fact that the military judge asked, have you ever been coerced, or were you coerced into doing any of these things? And he said no. But that's just a mere recitation of, or a conclusion of law drawn by the accused without any real analysis. So we don't see any point or any particular point in the record where the duress defense was established does not apply.
Please, I interrupted you. Go ahead, counsel.
Well, Your Honor, the government plucks two quotes to support its argument. This court should determine whether or not the duress defense was plausible or credible. They pluck those quotes from United States versus Ollinger and Faircloth. They don't give any facts of either of those cases. In Ollinger, the accused there went UA shortly before deployment. He pled guilty to going UA, and then in his unsworn statement in sentencing, he said that he felt his wife's depression combined with the stress of his deployment could kill her. And Cat found there simply that vague speculation didn't raise the duress defense. And in Faircloth, the facts are even further reflect than Ollinger and here. In Faircloth, the question wasn't even about whether a defense was raised. What it was about was whether or not the accused had established enough facts to show that the Ford Motor Company had the superior interest in the check. In both of those quotes, the government actually pulled directly from United States versus Marcy. Marcy used them there simply to recount the history of the Providence inquiry. It had nothing really to do with the case. None of those cases are controlling here. What's controlling here is United States versus Lee and United States versus Smith. And based on the appellant's testimony, where he said that his pregnant girlfriend was threatening to get rid of this baby if he didn't buy this house for her. In addition to that, the military judge's notation that, oh, she's holding you emotionally hostage. That should have been a signal to the military judge that he should go into the duress defense. And Article 45 doesn't just say that you should. It says the military judge should be vigilant in rejecting irregular or improvident pleas. And if this would have been a not guilty plea, if some evidence was put into the record on the duress defense, the judge would have had an obligation to sua sponte give the duress defense instruction. Here, the quoted language certainly is some evidence of the duress defense. The military judge never inquired into the matter. And the government wants this court, instead of answering that question, whether the potential duress defense was raised, instead wanted the court to determine whether or not it was plausible or credible. Lee clearly says that is not the job of this court. And finally, on that particular issue, during a Providence inquiry, the military judge's job is not to be a trier of fact. It's to elicit facts from the accused. And where he sets up an inconsistency, his role is to resolve that inconsistency or reject the plea. Here, the military judge didn't do that, and as a result, the plea is improvident.
Go ahead, counsel. Anything else?
We have nothing further at this time on the duress issue, Your Honor. I don't know if you have any questions on the impersonation issue, but for the most part, that is our argument on that.
Somehow, counsel, I think most of our questions are for your colleague. I'm not sure right now. We'll have to wait and see.
We have no problem with that.
Captain Liebenguth, let me ask you this. If the military judge's job under Article 45 is to resolve the inconsistency or reject the plea, and the military judge did not reject the plea, can we infer that he therefore resolved it?
You can't, Your Honor, because, again, what Lee says is the military judge's role there is not to resolve it in his own mind. His job is to elicit facts from the accused that would resolve the inconsistency.
Well, now, Captain, he has to resolve whether or not a defense exists. He has to see if facially it exists. And once it has been established, then he can determine through inquiry whether or not he can, under care, still accept the plea, right?
Yes, Your Honor. I don't mean to overstate it. Simply, the judge never did any inquiry whatsoever. But he doesn't get to resolve these things in his own mind, which is what the government argues, that we can assume that he did this analysis in his head and determined that it was not raised.
All right, kind of tangential to Senior Judge Booker's inquiry. By way of remedy, could the court go back at either the government's prompting or on our own initiative and have this matter? A Dubé isn't going to buy us anything here, is it, counsel? I mean, there's no set of facts one could garner. One would have to have a rehearing. I don't see another remedy if, in fact, we determine that the judge did not inquire on a defense and that inquiry was mandatory and contaminates the plea.
We agree, Your Honor. No further questions? That concludes my argument.
Well, I actually do have a question, and it relates to the assignment of error with respect to the Article 134 language. Help me understand your point about the distinction between officials, whom you categorize as non-commissioned officers and up, and employees. Where in the language of Article 134 do we draw that distinction? And I'm particularly concerned about the final sentence, I think it is, which talks about impersonating an official of a certain government.
Yes, Your Honor. To start out, we would say that we have to compare because 18 U.S.C. Section 912 with paragraph 86. And the reason we have to do that is because per United States versus Young, the elements of paragraph 86 are based off of Young. And Young does an analysis of Section 912. So what we have is the drafters, when they created these elements, had in front of them the elements of Section 912, which clearly includes both officials and employees.
Of the United States.
Of the United States, Your Honor. If for whatever reason, they excluded the term employees in paragraph 86. And as you pointed out, the difference is Section 912 only applies to the federal government. With paragraph 86, it doesn't just apply to the federal government, it's any government. And quite frankly, that's somewhat vague. We don't know if it's the federal government, state government, the city government, or the equivalents of those governments in foreign lands. But if you include employees, the reach of paragraph 86 becomes almost absurd. Because if you look at the rest of the things that paragraph 86 seeks to prevent, that is the exercise of superior authority, NCOs and above, agents of superior authority. If we include employees, which possibly could stretch to city governments, then you have servicemen who could potentially be committing an offense for impersonating a low-level city employee. And that is not what the elements, this paragraph 86 seeks to prevent. And there's no definition given. We don't have a definition, either from case law or from the paragraph itself, of what an official is. But certainly Section 912 makes a distinction. And when the elements were created for paragraph 86, they had that distinction in their mind because they were looking at Section 912. We believe that the bright line rule, and it is a bright line rule we're asking this court to draw. The bright line rule is that an official of a certain government under paragraph 86 is someone who is appointed or elected to an office, to a position. And even with that bright line rule, this is one of those cases where it will have very little effect on military justice practice because this type of charge, has rarely been ever brought against a serviceman. Appellant could only find 2, and neither of them survived appellate review.
Counsel, isn't the statute, though, necessarily nebulous? For instance, at what point would we draw the line? An SES 1 at the Department of Transportation is a public official, but the GS3 answering telephones and earning his or her money proudly is not? I mean, where is the line? I mean, the janitor, who's probably working harder than any of them, is not an official. With the intricacies of the draw out of government schemes, where can that line possibly be drawn?
It can be drawn at, is the person, the official, is he elected or appointed? Appointed by whom? We're sitting on this court today appointed by the Judge Advocate General of the Navy, who's acting under the authority
imposed upon him or delegated to him by the Secretary of the Navy, who's acting under the authority granted to him by Congress and the President. Isn't this a very much you know it when you see it issue, where the individual has executive authority to act? And with that in mind, if we forget for just a moment, for the sake of argument, that the appellant in question here referred to it as the Veterans Association, perhaps another name, and then the Veterans Administration in his colloquy with Chief Judge McKenzie, if we just for a moment assume that he was acting supposedly on behalf of the Veterans Administration by way of a home loan issue, couldn't he arguably be considered an officer?
Your Honor, what you pointed out is the ambiguities in the statute. And maybe he can be considered that way. We disagree, but at the end of the day, those ambiguities...
But counsel, your client pled guilty.
He did, Your Honor. He didn't know what he was pleading guilty to, Your Honor, and neither did anyone else in that courtroom. The military judge himself, although he used the word official in passing and during the Providence inquiry, he also asked the appellant whether he'd ever been an employee.
Alas, then, counsel, where, pray, is your ineffective assistance of counsel argument if no one in the courtroom knew that what they were convicting or, more importantly, from your shoes, pleading their client guilty to?
Yes, Your Honor. The ineffective assistance of counsel burden or hurdle, Your Honor, is much higher. Appellant decided to go with his strongest arguments. Believes that the impersonation issue is stronger than the IAC issue. That's why we led with it. If there are no further questions, that concludes my argument.
I'm not sure that I have no further questions, so let me beg your indulgence for a minute.
Yes, Your Honor.
I want to return to this language about an official of a certain government.
Yes, sir.
And this ties in with Senior Judge Maxim's question. I mean, at what point do we say that the United States way of doing business is the only way of doing business and reject other foreign governments, for example, who may not have an advice and consent process such as our Constitution provides, or a state or municipal government whose appointment authority may reside in the elected members of a school board? Where do we draw that line? And when we determine where we draw that line, does that give us a substantial basis in law or fact for determining that this plea is not provident, that the military judge abused his discretion in accepting it?
Well, if you draw the line where we ask the court to draw the line, Your Honor, at an elected or appointed official, where that particular, and I should elaborate on my last answer regarding that, elected or appointed official whose position is governed by statute, then I think we have a sufficient line that we know what we're talking about. Right now, what the court is basically pointing out, the appellant thinks, is that there's a vagueness issue with this particular statute. Now, we didn't raise a constitutional vagueness issue here, again, because the hurdle to get over for a facial challenge is extremely difficult.
Counsel, maybe this would help.
Yes, sir.
You answered Senior Judge Booker's question with more granularity. Would you agree with me that, now I've never used this process, but some of my colleagues have been educating me, getting ready for this case. Would you agree with me that a home loan official with the Veterans Administration, when committing the sovereign power of the United States of America to up to $380,000 or $85,000 in guaranteed encumbrance, as it were, to the taxpayers of this country, is acting with the full faith and credit and sovereign power of the United States, the Congress, and the executive?
As an employee, yes, sir, but not as an official.
So this employee can bind a sovereign, but we shouldn't apply criminal liability to those who abuse that sovereign?
The distinction, Your Honor, is the employee is really not. He didn't come up with the policy in which the binding is allowed. He didn't come up with the procedures required to be followed for that binding to be allowed. We have lance corporals in the Marine Corps that can commit thousands of dollars to funded law programs and other things, pay bills for those types of things. And yet, if you or I, or even if an E1 were to impersonate that lance corporal, certainly wouldn't be charged under this paragraph 86, but they would nonetheless be committing some offense. That's the case here. We're not challenging that Corporal Susi committed no offense. Had they charged him under 18 U.S.C. Section 912, we're not sitting here discussing this issue at all. And as this court has said in the past, the judiciary plays no role in the charging decisions of the government. And the government must bear the burdens of those charging decisions. Here they charged him under paragraph 86 when they should have charged him.
Oh, you can say it, counsel. The wrong statute.
The wrong statute, Your Honor. Or they could have charged us under. They could have assimilated Section 912 under Clause 3, or they could have charged him with the novel spec under Clauses 1 and 2. They failed to do that, and they have to live with that burden now. Is there no further questions? That concludes my argument.
Thank you, counsel. Good morning, Mr. Berkman.
Good morning, Your Honor. May it please the Court. As to the first granted issue, whether an official of a certain government can constitute employees, the answer is, it depends. It depends on the facts.
Berkman, let's talk duress. You would agree with me that in any case, a military judge, when presented with a prospective defense, he doesn't have to reach conclusions as to the ultimate applicability or success of the defense, but in a care setting, if he's presented with the four corners of a seemingly viable defense, or even a defense which it's apparent to him from the record that the accused believes he is espoused with the defense, that he has a mandatory duty to seek out and either confirm the existence of that defense or seek out and essentially judicially dissuade the applicability of the defense. Right?
Yes, Your Honor, but that depends on when that duty is triggered. The military judge's duty to question is not triggered when it's the mere possibility of a defense. It is only triggered once an inconsistency has been raised, and that's the question this court is now faced with, whether the appellant's statement about his girlfriend getting rid of the baby was a mere possibility of a defense, which requires no duty of the military judge to inquire further, versus raising the defense, which the government contends is much more akin to explicitly or implicitly establishing all of the elements of the defense, as was done in United States v. Lee, the case that the appellant relies on. There, the impossibility defense was established by the accused during his sworn testimony, saying, I couldn't start my car, I couldn't make it to the UA, I was UA because my car wouldn't work, I tried to do all these things. Whereas here, we have a passing reference, much more akin to what occurred in United States v. Ollinger, which Kapp characterized as the mere possibility of a defense. Since this was similar...
Would you agree with me, though, Mr. Berkman, in order to segregate the wheat from the chaff, the mere possibility or the potential flippancy of a prospective defense versus, wow, this defense may well apply to this case, time to put the all-stop sign down in the engine room, and we have to do something here. You have to ask the questions in order to find out what the answers are. And if all the trial judge has before him is the prospect of the defense raised, and then does nothing, ceases answering questions. In fact, the only questions he does ask garner answers that further exacerbate the possibility that the defense exists. Isn't there an absolute calf-driven affirmative duty on the part of the judge to inquire? I'm not for a moment asserting that there's an actual defense here that may be viable in the end. I don't know. I can't take the judicial Ouija board out because all I have before me is the record.
Yes, Your Honor, and CAF has case law directly on point for that. Courts don't speculate post-trial as to facts that will negate a guilty plea, and that is what appellant is seeking
Except
to do.
If a duty on the part of the trial judge is raised and then without explanation abandoned or not pursued. I mean, isn't your problem here not the question of whether the prospective defense was possible or impossible? I mean, impossibility as a defense may well apply to other aspects of this case, Mr. Bergdorf. But isn't the real problem here one of this distinguished member of our judiciary had a bad day, didn't do his job that day the way he ordinarily would have done it, were left on a lurch, and under care, this court is given the mandate to review, and under 6.6, we're given the mandate to review each and every plea and determine whether there is any matter which is contrary to the fundamental rights of the accused, and either bless it or not. And in this particular case, aren't we left with just not enough information?
No, Your Honor, because this is not an inconsistency. Because the military judge's duty to inquire further was never triggered. Because the passing reference did not amount to the duress defense, did not amount enough to raise the military judge's requirement to inquire further. And we have
it's not a passing reference, though, Mr. Bergdorf, is it? Because, I mean, indeed, in your submissions to this court, it's the before this issue was even specified by the panel, you raised it in the first few pages, if not the first page, substantive page of your brief. This appellant had argued this throughout the trial. It was a motivating factor in his actions. This entire scenario, which some might argue belonged in a civil court, this entire scenario plays out with him using the excuse of, I thought my girlfriend was going to do something terrible. Amongst them, my unborn child was going to die. It's raised.
Well, Your Honor, let's explore that.
It's raised to the point of having to be asked about.
Well, in the same respect, Ollinger raised the defense by saying my girlfriend was I was afraid she was going to kill herself because of the depression. In the same sense, that was raised. So the question becomes, what is your definition of raised? And raised must approach much more than a passing reference as in Ollinger. It must be actually establishing the defense and really saying, we don't know here, we have to speculate. Was she talking about an abortion? Was she talking about an illegal abortion? Possibly, was she in the third trimester?
We don't know.
Well, and that's Senior Judge Maxim's point, I believe, is that we need to speculate as to what he actually meant. We need to speculate. What did he mean? What did she mean by get rid of the baby? Does that mean put it up for adoption? Does it mean take it to...
Yes, Your Honor, and that's the speculation that courts don't indulge that will negate a guilty plea.
Well, I understand that, but isn't it incumbent on the military judge who's sitting there seeing all this unfold to ask a question or two? Well, what do you mean by that, Corporal Soucy?
Yes, Your Honor. If an inconsistency has been raised during the Providence inquiry or possibly during sentencing, but this
didn't he say I wouldn't have done it if I hadn't thought that my girlfriend was going to go crazy? Not in so many words, but isn't that the gist of what he was saying in response to the military judge?
That is what he was saying, Your Honor, but is that an inconsistency? When abortion itself, if the military judge seeing the accused in front of him and took that to mean, he said, I found out about it, so maybe this was very early on in the process. This is possibly not even an unlawful activity. So the duress defense would then not be raised. There's no immediacy. There are three reasons why this defense wasn't raised by that passing reference.
Are you saying that the duress defense requires on unlawful activity by somebody else in order to make it viable?
Yes, Your Honor.
All right, so if I know that if I don't go UA tomorrow and offer up a third of my liver to save my wife's life, she'll die, I don't have a duress defense?
Your Honor, based on the state cases cited in the government's brief, state cases have held exactly that. The threat must be of unlawful activity because the policy behind the duress defense is that the lesser harm is more desirable for the public than the greater harm. So it permits the justification to commit an unlawful activity when faced with the threat of a greater lawful activity. And that's reflected in RCM 916H by the fact it's not a defense to killing.
Yeah, how about the state of military law as to duress, though? Spertorp, wouldn't Senior Judge Booker's exemplar carry a bit more water than one can carry when one goes to the state court sites that we were tending?
Well, Your Honor, there are other reasons why the duress defense did not apply in this instance. There's lack of immediacy.
No, please answer my question.
Could you repeat the question?
Sure. You've cited us to state cases, and you just answered Senior Judge Booker's inquiry along the lines of, well, if you look at the line of state cases, Your Honor, we're led to believe there must be a nexus with a criminal activity, i.e. it has to be something that could be prosecuted. Is that the case when one simply looks at military and federal law?
Well, yes, Your Honor, but the nexus is different. In the military law, we have Army case, United States versus Barnes. And there, the Army court required the nexus to be, the threat must be to actually commit an unlawful activity. When there, the robbery was done to pay off a debt, the threat was not, you must commit a robbery. The threat was, you have to pay a debt. So here we have the same lack of a nexus. The statement was, you have to acquire this house for me. She's not saying you have to impersonate government officials. She's not saying you have to fraudulently.
But the end game is the same. I mean, let's all be frank here. This case has as its font of prosecution the vice chairman of a Marine Corps Alumni Association in Northeast United States, who happens to still be affiliated with several senior NCOs with whom he is openly laughing about the prospect of a corporal purchasing an $800,000 and some odd mansion. And as a result of his nexus with these same Marine Corps personnel, this case has its criminal impetus. So, I mean, this goes both ways. When I look at this case, I'm left with one comment and one query, counsel. Where's the crime? I have immoral conduct. I have deceptive conduct. But as the United States has charged him, where's the statutory offense? He creates a Yahoo account, which he places, he can't even get the first name straight. The last name's White, I believe. He creates this to send it to a real estate agent, not for the prospect of purchasing the home, as the trial judge erroneously concluded, but for the prospect of purchasing time, so that he can convince, and no one talks about this in their briefs, so that he can convince his girlfriend to purchase with him another home, not this one. Yet all the characters at the trial level play into the fact that he's attempting to purchase this home. And I have to tell you that we're left with the prospect, where's the offense? What's the crime?
Well, Your Honor, the government already conceded away the first 123 charge, and the remaining offense, the impersonation of government officials, which I'll switch to if Your Honor so desires. The crime there is he impersonated officials of a certain government. And the court's question is, did he provide sufficient facts to satisfy the elements? And there's the crime, Your Honor. He did impersonate Adam and Jim White. He admitted that these
Is
were
the Veterans Association an entity of the United States?
Your Honor is correct. He did say that, and then when the military judge presses him on it and questions further, he says Department of Veterans Affairs and later...
And if we look at Abinet and we look at other cases, we find that CAF has been cautioning trial judges not to lead the appellant into what he should and shouldn't place within the contents of his care responses. Isn't that the theme that we have? And I know I'm taking you in different directions, counsel, but you're very good at what you do. You can handle it. The reality is this is a mess from stem to stern. We have a prospective defense which isn't inquired upon. We have an offense which he's convicted of, gets 10 months, a BCD, and a $10,000 fine for a matter which arguably belongs as a piece of civil litigation in which, by the by, the primary defendant would not be the corporal, but the real estate company.
Yes, Your Honor. And as to the sentence, that would be a sentence appropriateness issue, which the appellant has not seen fit to raise. And back to the criminal offense, Your Honor, he said he was impersonating an official. He said this was someone representative of the government. And I'd invite Your Honor mentioned case law saying you don't lead the accused. Well, I'd invite the court's attention to the recent CAP cases in Ferguson and Garner, which appeared to be a sea change in the paternalistic approach of old from CAP, by quoting Brochet and bringing CAP's review of guilty pleas much more in line with the way federal courts review guilty pleas, by saying he gave up his chance to challenge the prosecution's theory by pleading guilty. That sounds much more like waiver than the paternalistic approach of old.
But he hasn't given up his opportunity to challenge whether the specification states an offense.
Correct, and the government conceded that one away at 123.
Well, under the 123A you did, but not under the Article 134. And my question now gets us back into the days of Yum, which is, why was this not charged as a violation of Section 912 if, in fact, the harm that he committed was impersonating an employee of the United States? Why instead do they choose to use this vehicle of Article 134, paragraph 60, I believe everyone has said it is, in which they say he is impersonating an official of a certain government?
Your Honor, I can't answer why the government chose to charge the way it did, but I can answer that the facts as revealed by the accused in the Providence inquiry satisfy the elements of paragraph 86, the specification on Article 134. An official of a certain government, the appellant wants to characterize official as vague, and the government would say it's intentionally broad. The appellant notes the existence of E4s, petty officers and non-commissioned officers, agents of a superior authority, very broad terms. And also we have this language, official of a certain government. Now, could the president have intended to broadly include employees of the DOD with agents of a superior authority and E4s, yet intend officials of a certain government only to include elected and statutorily appointed officials?
Well, I think that's not what he intended, but I do invite your attention to Article 5 of the Uniform Code of Military Justice, which says that this chapter applies in all places. And I got to think that what he's talking about there is officials of foreign governments, officials of state governments where shipyards and naval stations happen to be located, and things of that nature. He's not talking about employees of the United States who are clearly defined or clearly talked about in Section 912 of Title 18.
Well, Your Honor, official is a broader term than merely officers. And Your Honor is correct. It broadly includes foreign officials, broadly includes state officials. It also broadly includes civilian officials that are non-DOD, as was the case here with the Veterans Administration. I guess looking at the genesis of the language might be helpful, Your Honor. In 1948, Congress passed 18 U.S.C. 912. In 1949, the Army Manual for Courts Martial has the first appearance of impersonation charge, immediately in reaction, according to Young, to the 18 U.S.C. offense passed by Congress. So the president is modeling that language. And in 1951, when the Manual for Courts Martial turns purple, the title of that offense is impersonating officers, etc. And then this is the first appearance of official of a certain government. This is intentionally broad, Your Honor. This is intentionally broad because the plain language of official includes those vested with the authority of government. And as Your Honor, as Senior Judge Maxson pointed out before about delegation, that commonly occurs. Employees would be vested with the authority of an office through delegation.
Well, if the Joint Service Committee were basing the language of paragraph 86 on Section 912 of Title 18, why didn't they just include in there employee of the United States and then add the further provision for officials of a certain government?
Because, Your Honor, the term official broadly includes both. It would be redundant to add employees. They couldn't use the phrase. The President could not use the phrase officers or employees because officers means something very different in the military than it does in the civilian world. So that phrase cannot be used. So they use the word official.
That's not quite so true, though, counsel. Executive commissioned officers in the White House, for instance, are statutory creatures of the law very much akin as commissioned naval or military officers. So one has to be careful drawing broad strokes here. These positions, those founded under the authority of the executive and confirmed by the upper house, are intentionally created positions. They're special positions as completely segregated from those positions delegated to a much lower level of appointment process. And while I find counsel's urging this court to accept only those who are appointed or elected into this category as somewhat overbroad, the reality is there's appointments and then there's appointments, big A and small A. And there are several individuals, who are appointed as subordinate civilian personnel who hold no great office but hold great sway. And those individuals, I don't believe, are contemplated in the statutory sense. That's your problem. I mean, like brother counsel, you're failing to draw for this court a reasonable line where we can discern what's in and what's on the other side of the fence by way of what's encompassed definitionally in the statute.
Well, Your Honor, that brings us back to the way Ferguson analyzed the guilty plea. This court is answering that question by looking at the facts of this case and determining did the appellant provide sufficient facts to satisfy this court, official of a certain government. And what did the appellant say? The appellant said, I can release the funds. In his email as Jim White to Ms. Bedoli.
From the Veterans Association.
Your Honor, he used that term, but he also used the term.
He then adopted Chief Judge McKenzie's term.
Yes, Your Honor.
Just the same trial judge of very distinguished background who on this particularly unfortunate day didn't inquire into a defense. And my point being, counsel, I'm not trying to be flip with you, of course, is at what point under our mandate do we simply say enough?
Well, Your Honor, enough is that this satisfied the guilty plea. Whether he provided sufficient facts to satisfy the elements of the offense is this court's only question as to the first issue. This court doesn't need to address the broader, does employee satisfy official of a certain government? That is a very similar issue that CAF declined to address in Garner, whether the 18 U.S.C. 2244 offense, whether it was a crime to entice a minor under the facts of that case. And CAF said he pled guilty. We aren't going to address the broad legal question. He admitted sufficient facts to satisfy the elements. And that's how this court should face this issue. Did he provide sufficient facts to satisfy official of a certain government? He said it was official. He said he impersonated two individuals from the Department of Veterans Affairs. And yes, Your Honor, he did use the word Veterans Association. But he said, I can release the funds. I, a person vested with the authority to disperse funds of the United States government.
Counsel, how much do we have to take when we inquire into the four corners of the legitimacy of the plea, the voluntariness of the plea, the legitimacy, the factual basis of the plea? When we're looking into these matters, is it proper for us to look beyond to an associated issue such as what steps were taken to actually purchase this home? For instance, I know there was never earnest money applied here. Indeed, this individual could not even come up with the $500 deposit required to advance the purchase agreement. The same purchase agreement upon which the homeowner, the vice chairman of the Northeastern Marine Corps League something association, takes action to hire an attorney at his own expense in the amount of $1,500, a matter which comes in sentencing in this case. At what point can we honestly say that with those facts known to us, we can be satisfied that the underpinning required to sustain the conviction which you're arguing for us to sustain even had a factual basis to it. I mean, there's no... Where's the fraud here? Where's the money that's going towards purchasing anything, a widget, anything, let alone an $800,000 mansion?
Your Honor's point is well taken, and that's why the government conceded away the first charge.
I understand that, counsel, but doesn't that same deficiency contaminate the rest of the plea? Because the entire plea, this case was about, when the folder first ended up in Chief Judge McKenzie's chambers, the case is about a Marine who fraudulently attempts to acquire a large home which he could never pay for. That's this case. What do we have left in the edifice and ruins of this case? We have the government claiming that he's acting as an official of the United States, an officer of the United States, in creating 2 Yahoo accounts where he can't keep the name straight, representing the Veterans Association.
Well, Your Honor, whether he's a savvy criminal, clearly he is not. But did he plead guilty and provide sufficient facts to satisfy the elements in paragraph 86? And the answer is yes, Your Honor. He said he impersonated an official. He named those officials. He described the telephone communications and email communications wherein he impersonated an official that he claimed to have the authority to release funds. That satisfies the elements, and that's this Court's only inquiry as to the first granted issue. Briefly turning back to the second granted issue, and I'm happy to answer further questions on the first granted issue if the Court so desires, but I didn't get to the immediacy aspect of the duress defense. So, a military judge who's presumed to know the law, and here's this flippant statement which he recognizes that raises the mere possibility of the duress defense.
How do we know he recognizes that? He asks 1 or 2 questions.
Because he acknowledged it, Your Honor. Because he said you're being held hostage, not physically, just emotionally. So clearly he heard, recognized, and dismissed the duress defense as inapplicable because he recognized it properly, as he's presumed to know the law, as the mere possibility of a defense. Purchasing a home inherently is a time-consuming process. So even if we were to presume that his girlfriend said, I want you to not buy me a home, I want you to fraudulently buy me a home. I want you to impersonate government officials when you do so. And unless you do that, I'm going to get rid of your baby. So let's presume, for sake of argument, that she said that. That's still going to take time. RCM 916H requires immediacy. There is no immediacy in this crime. There is no immediacy in purchasing a home because it takes months sometimes, especially when you're dealing with the Veterans Administration and trying to qualify.
But doesn't the factual scenario ill-serve you along the lines of that argument? Because what's described for the record is this constant rearguard action that he's running, this, and I'll use the term deception. He's clearly being deceptive. This constant deceptive rearguard action where the appellant is constantly saying, well, I'll do this now or then, later, I'll get guarantees for you, we'll meet at this place. I mean, there are constant interregnums that are created, and then a meeting spot, and then that's not complied with. I must tell you, a plain reading of the record would lead me to believe that no 2 parties involved, such as the owner of the home and the real estate agent, after the first few instances that occur in this case, could realistically have believed they had a prospective homeowner on their hands. And doesn't that almost raise impossibility at some point here? I mean, he's wrongly identified the government agency in question. The government could have charged us under another aspect. That's not our area of competence, but how can we, I mean, in the end of the day, Mr. Bergdorf, we have to be satisfied that there was a knowing, voluntary waiver of rights, that there was a knowing plea, and that the plea was based upon a proper factual basis.
Your Honor, I believe you want to focus on the 123 charge, which the government conceded.
No, I don't. I'm not even thinking about the 123 charge. I'm thinking of when a sitting trial judge hears a guilty plea, he cannot eradicate from his mind the factual underpinnings of the litigation. what got the accused in his courtroom. Because the charge itself, for instance, an official of the United States, pretending to be official of the United States, the charge itself has as its underpinning a criminal act. Why is that official, quote unquote, contacting the real estate agent? Well, because of the real estate effort. Well, there is no real estate effort. There is no attempt to garner the property.
Well, Your Honor, the broader facts are definitely pertinent to the guilty plea and
That's my
placed it in
point.
context. But the offense that remains at issue before this court is merely his actions within the broader factual scenario of attempting to purchase this house. And clearly, Your Honor mentioned why did the real estate agent believe that this was a legitimate purchase? Why did Mr. Enos believe? Perhaps it was a desperation of the real estate market, Your Honor. They actually had someone interested in their house, so they were willing to believe, despite the feeble attempts of the appellant to claim he was good for the money. But that's not the issue, Your Honor. Did he admit sufficient facts to constitute impersonating a government official? And he did. And that's the narrow focus of this court. In trying to purchase this home, he impersonated officials. And that's all this court is faced with.
Lieutenant Bergdorf, let me pin you down in your remaining 30 seconds. You keep mentioning Garner and how the Court of Appeals for the Armed Forces has moved away from this paternalistic view of military justice. But didn't Gunnery Sergeant Garner understand the terms and definitions to which he was pleading? And can we really say that Corporal Soucy, and for that matter anybody else in the courtroom, understood the terms and definitions that were at play here?
Your Honor, appellant acknowledged a moment ago in oral argument that official needs no definition because everyone understands it. It has a plain meaning. This is not a legal term of art that required defining by the military judge. So yes, Your Honor, he did properly understand the elements of defense when he voluntarily pled guilty. Unless there are any further questions.
Thank you. Counsel?
Captain Liebenguth, do you agree with Lieutenant Bergdorf's assessment of your concession with respect to the term official?
That was going to be my first point, Your Honor. What I said was the drafters understood it to be plain. No one in that courtroom, as you pointed out, Your Honor, understood its meaning. In addition, regarding impersonation, the trouble, or the very discussion about what official is, simply points out the ambiguity. And as Yum says, it cites Supreme Court case Campos Serrano. Under those circumstances, that ambiguity is resolved in favor of the accused. And in such circumstances, the narrowest possible construction is applied. Second, regarding duress. RCM 1916H in the discussion section says that the immediacy of the harm depends on the circumstances. You have to put it into context. Here, at the end of the day, if Barbara discovers that he can't buy this house, potentially, she's going to abort the spade. That's the crux of it, and the military judge never resolved that inconsistency. Second point regarding duress.
Can I stop you there and ask
Yes,
you,
sir.
did the military judge actually resolve the inconsistency? I mean, I'm looking at Lee as your strongest case, and you have Article 45 that, the plea is entered and a matter inconsistent is set up.
Yes, Your Honor.
And the duty laid out is upon the military judge to inquire into the circumstances. Does he not inquire?
Well, certainly, no, Your Honor. We believe that first he cements the inconsistency by noting that she is holding him emotionally hostage. If you're referring to where he asks about whether he was forced or coerced at any point, Your Honor, is that... Because I see nothing else in the record that indicates that he inquired
The
further.
comment following the termination of the pregnancy is then responded to by the military judge saying, she's holding you hostage. I mean, not literally. Emotionally, she was holding you hostage. Is that right? Yes, sir. So we have a mere possibility of a matter set up in contradiction to the plea. We have an inquiry by the military judge, and then we have the appellant agreeing to a state of affairs that no longer invokes the duress defense. Is that
No, Your Honor.
not a fair read?
I think there the judge was actually accurate. If she was holding him literally hostage, he certainly won't be able to buy the house or do anything else. He'd be being held against his will somewhere.
Well,
So
isn't there
I-
a further duty on the military judge to inquire as to whether the accused persists in the statements and then reject the plea at that time?
I'm sorry, can you repeat that, Your Honor?
Sure, I'm just reading from Lee. It says, and if the accused persists in his statements to reject the plea, does he persist in his statements?
He was never asked about the statements other than that brief note by the military judge, Your Honor. So I think what...
Doesn't he
I think what
just
Lee
at that point subscribe to the fact that he was being emotionally pressured by his intended? Is that not the state of the evidence that Chief Judge McKenzie was looking at as he proceeded to follow with additional questions?
No, Your Honor. What Lee means when it says that if he persists is if the military judge, as he is required to do, attempts to elicit facts to negate the defense that was raised, and the accused just continues on and doesn't negate it, then at that point he has to reject the plea. But if he does not persist, then it's fine because he's resolved the inconsistency. The other point I'd like to address...
But ancillary to where Judge Perlak's coming from, though, indeed, isn't it the case, and this goes along with Lieutenant Brickhoff's comments to the court, that there's no mandate out there that articulates that the judge has to specify on the record, well, now I'm not concerned. I've resolved that. Isn't it that he has to present an inquiry that this court can objectively look to and say, he identified the issue and satisfied himself that there is no issue?
Yes, Your Honor. Had he asked the question that we've persisted from, based on Lee, do you admit and believe, Corporal Soucy, that you did not have a reasonable apprehension that this harm would occur if you didn't buy this house?
Well, that's
Yes,
the
I agree with
textbook
that.
version.
Yes, Your Honor.
But couldn't, along the lines of Judge Perlak's question, couldn't a reasonable viewer of this colloquy conclude that Chief Judge McKenzie identified the issue, it concerned him enough to ask the question, he asked the question, eradicated the physical aspect, and accentuates the emotional aspect of what's going on here. The accused agrees with him, adopts his understanding through his yes, sir, or yes, Your Honor, whichever it was. And Chief Judge McKenzie, objectively looking at what he's perusing, the trial judge in the courtroom, many years of distinguished service, I think on his 4th bench tour, says, okay, I'm done, and moves forward. Doesn't that garner the deference of this court? You have plenty of time. Go ahead.
Thank you, Your Honor. We don't believe, based on these facts, that it does, Your Honor. And this court should not give the military judge that deference in this case in any event. As the government noted moments ago, the judge is presumed to know the law. In this case, that presumption has been rebutted. Not only does the government concede our brief second assignment of error, but we also believe that if you look at our first assignment of error, the judge erred in finding him guilty of the 123 alpha charge as well. And as the court pointed out, there are other points in the record which are not only problematic but disturbing in terms of some of the sentencing evidence that came in and the relationships that existed between these three parties. The last point I would simply make is not one substantively, but we absolutely did raise sentence inappropriateness in this case, in both assignments of error 5 and 6, with 6 being our excessive fines clause under the Eighth Amendment. So, for many of the reasons that you pointed out, Your Honor, during the government's argument. If no further questions, that concludes my reply.
The matter is submitted.
All rise. The United States Naval Academy Court of Criminal Appeals now stands adjourned.